So there is a widespread misconception promoted online that forming Wyoming LLC automatically provides strong asset protection, especially because of so-called charging water protection. And you've probably seen advertisements saying that Wyoming is the best state for asset protection. Creditors cannot touch your LLC, form Wyoming company, and your assets are safe. These claims are often marketed not only to U.S. residents, but also to investors around the world. I'm Max Dilendorf. I'm an attorney based in New York, and today I want to explain how courts treat out-of-state LLC interests when a creditor is trying to enforce a judgment. The issue affects both U.S. residents and non-U.S. residents. And for foreign owners in particular, a Wyoming LLC can sometimes become a tax trap rather than a protection strategy, especially if the structure is created without proper tax and estate planning. So let's start with a simple question. If you own a Wyoming LLC but live in another state or another jurisdiction, and a creditor gets a judgment against you, why would that creditor go to Wyoming to enforce it? In most cases, they won't. Under federal rules of civil procedure, enforcement of money judgment generally follows the procedure of the state where the court is located. And this principle is illustrated in a recent and important case called 245 Park Member LLC versus NHA Group International Co. Limited. That was decided by the United States Court of Appeals for the Second Circuit in April of 2024. The Second Circuit is one of the most influential federal appellate courts in the United States, covering New York, Connecticut, and Vermont. Because New York is a global financial center, its decisions on judgment enforcement are closely followed across the U.S. and around the world. So in that case, debtor was H&A Group International, a Hong Kong company that owed roughly $185 million. The debtor owed 100% of a Delaware entity called H&A North America LLC. And like Wyoming, Delaware is well known for strong LLC protections and charging water limitations. So through this Delaware LLC, debtor indirectly owned valuable U.S. assets, including interests connected to a large office building in Chicago and a conference center in New York. After getting the judgment, the creditor asked the federal court in New York to order debtor to turn over the membership interest in that Delaware LLC. The debtor argued that Delaware law should control and that the creditor should be limited to charging water protection in Delaware. But the Second Circuit rejected that argument. The court explained that under New York law, LLC membership interests are considered property that can be used to satisfy the judgment. The court noted that ownership or membership interests in limited liability companies are clearly assignable and transferable. So because of that, the court affirmed an order requiring the debtor to turn over the entire membership interest in the Delaware LLC to the creditor. In other words, even though the entity was formed in Delaware, the enforcement court applied New York law, not Delaware law. So the same thing can happen to your Wyoming LLC when it ends up in out-of-state court. This illustrates an important principle. When creditors enforce judgments, court often apply the law of the forum where enforcement occurs, not law of the state where LLC was formed. We see the same principle in Wells Fargo versus Barber. In that case, debtor owned interest in a Nevis based LLC, an offshore jurisdiction known for strong asset protection statutes. Yet a Florida federal court treated that LLC interest as the debtor's personal property in Florida and allowed enforcement there rather than deferring to Nevis law. Now, let's briefly discuss privacy. Wyoming does provide certain privacy protections, but privacy is not asset protection. During litigation, creditors could obtain information about your assets through discovery, including depositions under oath. In addition, states like California may require residents who operate through an out-of-state LLC to register that entity as a foreign LLC, which can make company information publicly accessible. So forming an LLC in Wyoming does not necessarily keep ownership invisible. For non-U.S. residents, there is another major issue that is often overlooked: U.S. Tax exposure. Unlike U.S. citizens, foreign individuals generally receive only $60,000 for U.S. estate and gift tax purposes on U.S. assets. So this means that if a foreign owner holds U.S. assets through improperly structured Wyoming LLC, those assets may be subject to U.S. estate tax and gift tax with very limited exemption. So that's why foreign investors forming LLC created without proper planning can sometimes become a tax trap rather than a protection strategy. So the broader lesson from cases like 245 Park and the Wells Fargo versus Barber is simple. Entity formation alone is not asset protection. Real planning requires a broader strategy that includes estate planning, trust structures, proper asset titling, tax analysis, and in some cases specialized tools such as private placement life insurance. Asset protection is not about chasing the best state. It's about coordinated planning that considers where you live, where litigation could occur, and how courts actually enforce judgments. Before you move assets to Wyoming or anywhere else, take time to review if Wyoming LLC actually works for your situation. If you would like to go over your options, feel free to reach out for a consultation. Thank you so much for watching, and I will see you in the next episode.